slide. Hi, my name is Elina Gilbert. I am an attorney in the transactional department here at Hyman Sanchez. And today I'd like to talk to you a little bit about a forum we just had. It's called Owner-to-Owner Dispute or Association Issue. In this class, we focused on taking an event or a complaint that an association receives and figuring out a method by which an association can determine, is this something that we need to be involved in, or is this something that's just between two owners that does not require association involvement? And we looked at various scenarios, and we'll talk about some of them, but generally the kinds of things we talked about are, things like two owners not getting along, things like perhaps noises, barking dogs, loud parties, that sort of a thing, sometimes when you're not exactly sure what the situation is. So we established a few rules of thumb, which are really important when you're looking at these types of situations. And the first rule is you have to assume that the complaint you're receiving is true. Just assume everything that you're being told is true. And what that does is it allows you to review your documents, your declaration, your bylaws, your policies, rules, and whatnot, and make a determination of if these facts are completely true, these allegations that we're getting from the homeowner or whoever's complaining, do they constitute a violation of our governing documents? And the way to do that is you really need to review your governing documents and see if you can find a provision that specifically says, this type of behavior is not allowed, or this type of behavior requires approval, something along those lines. So the first scenario we looked at was actually based on a true story. It was a situation where it was two neighboring townhomes. They had backyards with privacy fences, and one townhome had a little old lady and the other had a macho kind of a dude living in there. They weren't exactly friends, to put it mildly. And the little old lady put up some cameras in her backyard on her porch, and the neighbor, he was convinced they were pointing into his yard and she was spying on him. She said, no, I'm not spying on him. This is for my safety. I live at home alone, and and it makes me feel safer. So what the neighbor did was he took this horrible, ugly, disturbing mask and he put it on a stick so it was peering over the privacy fence into this woman's yard. Of course, the woman completely freaked out and didn't want to go in her backyard while the mask was staring there. So this came to the association. And we looked through the documents, and there wasn't anything specific in the documents that said, you can't put scary masks behind the fence. You can't put cameras in your yard that your neighbors think are pointing at them. So none of this behavior was something that was specifically prohibited in the documents. There was a provision, and this is going to be a problematic provision for many associations. It's the typical nuisance provision that you find in your declaration usually that says, nothing may be done that's a source of nuisance or annoyance to someone else in the community or interferes with their quiet enjoyment of the property. That's such a broad provision intended as a catch-all. And sometimes homeowners take those provisions and say to boards, you see, this is annoying me, this mask is annoying me, those cameras are annoying me, so it is a violation of our documents and you have to enforce it. It is important to realize that these provisions are not meant to address owner-to-owner disputes. They are really meant to be catch-alls where there is something going on in the community that is truly against the spirit of the community itself, of the governing documents, but we don't have anything right on point that specifically says this is prohibited. In those cases, sometimes it's okay to use the nuisance provision as a way, to send a violation letter or something like that, but typically you are not going to go to court based on a violation strictly of a nuisance provision. Generally, you're going to need something more than that. So these nuisance provisions can be problematic. But generally, if there's nothing else in your documents that speaks to the violation itself, a nuisance provision is not going to be enough typically to make it an association issue. The next part in the analysis is if once you've looked at the facts and determined if there's a violation, you now have to look to see, okay, if there is a violation here, do we have proof of this violation? In other words, now we look to the alleged facts. So if they are true, it would constitute a violation, but do we know if these facts are true? These types of things really apply with the noise complaints. You know, the barking dogs, the loud parties, those things are pretty difficult usually for associations to verify. So you need to see if the complaint is something that you can verify. If it's something like, you know, my neighbor painted his house pink, certainly it's easy for the community manager or board member to drive by the property and see if it's pink. But when it comes to issues such as noise violations or my neighbors yelling at me and saying bad things to me, those types of things are much more difficult to verify. And so associations are really going to need to do a little bit of digging. In other words, you need to get some, either you need to witness it, either you need to talk to people who have witnessed it, if there's photographs, recordings, any sort of documentation that would help establish it. But otherwise, if you can't get any verification of these alleged facts, even if they do constitute a violation, an association simply has no basis upon which to enforce anything, because we can't figure out whether this state of circumstances truly exists and whether this is really a violation or not. I mean, yes, whether it's a true violation or whether it's just somebody making something up. And then the last item to really look at is, even if the facts do not themselves constitute a violation, might this be something that the association should step in and address anyway? And really what that was targeted towards were really things like smoking complaints, smoke odor complaints, those types of things. And generally in condominium communities, mostly because you have the ducts, the wiring, everything between the perimeter floors, walls, ceilings of a condominium community are generally common elements. So to the extent that an association has to make any kind of repairs to the common elements, or something can be done that would address the alleged complaint, the association might have a duty to take those steps to address them. Analysis is pretty lengthy and complicated as to whether the association does have that duty, but you should have a red flag go off that if you are in a condominium community and you have owners complaining that they can either smell something or they can hear something or someone's doing something possibly in another unit, it's at least worth looking into as far as, is there anything that, could this possibly involve a common element? Is this possibly something that might be defective on the association side that we need to go in and repair, or at least check to make sure that there's nothing wrong with it? So if you keep that in mind and go through the process of assuming the facts are true and checking the documents to first make sure there is or is not a violation, and then trying to verify the violation if it constitutes one, and finally making a determination as to whether the association needs to get involved, you will be on good solid ground. But of course, as always, certain situations require legal review, and we always recommend that you do contact your attorney if you're not sure. And if you have questions, please feel free to check us out on our website, which is below, and have a wonderful